Good evening, all. It's a great pleasure and a privilege for being with all of you on this. I call it as an August occasion. In addition to the Mrs. Sitaraman mentioned that conversion of the federal court into Supreme Court, today is also an auspicious day as per Hindu mythology. Today it's called as Radha Saptami, a festival in the name of sun god. So on this occasion, I pray the Almighty, the Sun God, to bless all of us, to take us in the right way, in the right direction, to come up with the right interpretation, the right understanding, and right rewriting of the Constitution if so required. So it is like a battle of war going on here. And I, being the last speaker, I heard many of the speakers who spoke before me. I consider them, all of them, as gurus, because I learned many new things, many new issues, many new facts on this day. So I bow my head to all the gurus, considering them as Guru Brahma and Guru Vishnu and Guru Deva Maheswara. My heartful pranams to all those gurus who spoke earlier and who enlightened on various aspects. Now coming to the point where Mr. Venkatesh has initiated in a very provoking and thought process way, that whether we should continue with the existing constitution or we should go for a new constitution. Taking spirit from that point, because I feel that all of you are in a sedition because of the injunctions that were given by the earlier speakers. So you don't mind even if I may not be up to their mark or up to their standards. But forgive me if I'm not up to their standards. I try my best to give you the picture in a different way, because I, being a serving civil servant and an advisor to the government of India, I have certain restrictions on my freedom of speech and expression, as the restrictions imposed under the Constitution under 19, 1 and 2 read with the limitations. So with these limitations, I start to share my views and thoughts on a very interesting, important topic, the Colloquy on Constitution. With a disclaimer that all these views which I will be sharing with all of you on this August occasion, with this August gathering, will be my personal views, personal thoughts, and personal ideas. Nowhere reflects either on my government or on my department. But I am proud that I am under an able government. Now, after hearing the various eminent speakers, including my chief law officer, the learned attorney general, I am fortunate to be one of his taught when I was at National Law School. And I also fortunate to work with him during the review of the Constitution under the chairmanship of Justice Venkatachalaya. So taking the inspiration from Justice Venkatachalaya, before we debate on the need of a new constitution or there is no need of a constitution, I draw your attention to one of the sayings, observations of Justice Venkatachalaya when the task of reviewing working of the constitution was entrusted to him. The first question that was posed by Justice Venkatachalaya was, does the constitution fail or the people fail the constitution? This is a fundamental question we must put to ourselves when we talk, debating, discussing about the working of the present constitution. So does really the constitution fail? Or we, the people of India, failed the constitution? If at all there is a failure on the part of the constitution, I take the stand that we all are responsible for the failure of the constitution. Because constitution basically creates three major organs. They are the judiciary, the legislature, and the executive. And the framework is set up, rightly or wrongly. I'm not going into the debate of the parliamentary debates or the assembly debates that took place prior to commencement of the constitution or post commencement of the constitution. But I am concerned about the legal and constitutional analysis of various aspects of the constitution and why today we are discussing about the need of a new constitution. What made us? To answer this question, I don't hesitate to say that it is the people who ruled us earlier, the people who executed us earlier, and the legislature who passed the laws earlier are responsible for failure of the constitution. I can demonstrate this dogma or this philosophy or this principle with few settled illustrative case law. At one point of time, there used to be a practice of sharing legislative proposals with foreign nationals. People have gone even to the extent of sharing our budget proposals before the budget is introduced in the parliament. I'm not exaggerating the things. All these are in the media. All these are in the public domain. It has been fairly admitted by Mr. Sanjay Baru in his book, Unbecoming Prime Minister. It is clearly evident that earlier the people have shared the budget proposal with a foreign country, and once the foreign country approves the principles, that budget is introduced. Now you tell me, is it the failure of the constitution or failure of the people? Failure of the people. So therefore, the question today, to put us, as Mr. Nageswara sir has rightly said, it is very difficult to come up with a new constitution. Framing of a constitution, a new constitution, is a challenging task, is an Herculean task. But it doesn't mean that we should remain silent and we should bear this burden forever and ever. Because the law, being a living organ, cannot remain static. It has to undergo changes. It has to grow with the growth of the society. It has to change with the change in the minds of the society. It has to change according to the change in the culture, attitude, ideas, thoughts of the people of the particular territory, a particular region. That's how the neighboring countries have come up with a new constitution. So taking this ideology into consideration, I share a few cases as I mentioned. There are some good practices with reference to the Indian constitution. There are some bad practices. But it is we to analyze why the good is missing today and why the bad is increasing today. Some of you raised a question about the duties versus the rights. Fortunately or unfortunately, the Indian constitution speaks about rights and duties. Rights and duties are correlated to each other. Where there is a right, there has to be a duty. Because they're coupled with each other. It is again the decision of the Supreme Court instead of Rajasthan versus Vidyavati. The rights and duties are correlated to each other. So when somebody's right is infringed, it means somebody is failing to perform his duty. Now tell me whether if there is any failure on the part of the performance of the duty, it is a failure of the constitution or failure on the part of the person. Now the second aspect. Again, unfortunately or fortunately, the focus by all the three organs, the legislature, the executive and the judiciary, is only on promoting of the rights, not on promoting of the duties. It is only in the recent past I have seen and I am witnessing the government taking initiatives to highlight, to educate the people on the duties. I never seen any public office keeping a big hologram or a photograph highlighting about the fundamental duties of each and every citizen. Now today you go to any public office, you find holding a big board there and ascribing or prescribing about the fundamental duties of the people. This is one incident I want to share about the failure of the constitution or failure of the people. Now coming to the second important aspect, a very important crucial aspect. Some of you raised a question about appointment of the judges and the conflict or the tussle between the government and the judiciary. I'm not touching about the powers or the domain or the turf of the two organs in this regard, whether it is a turf of the judiciary or the turf of the government. I'm not debating on that. But I just keep a few facts before you because you are the people who are responsible for molding the constitution in the better way. In this connection, I recollect one of the sayings of one of the eminent judges of the world, none other than Lord Denning, a British judge. He once quoted about commenting on the constitutional values or constitutionalism because Britain doesn't have any written constitution. They don't have any written constitution. But it is one of the well-administered, well-organized society in the world. People say that we are the very proud country. We have the best administrative system. Even if you ask me about their administrative law, they say, we know nothing about administrative law. We are not intended to know about the administrative law. But all the administrative principles emanates from the British common law system. He once quoted, even if you have the best law in the world, even if you have the best law in the world, if you have the worst people with you, they will make the best law into worst law. Even if you have the worst law in the world, if you are the best people with you, they'll make the worst law into the best law. I unquote. This is what Lord Denning said. So, to analyze this, I'm just keeping an example, a live case in front of you to analyze about the functioning of the Constitution of India. At one point of time, there was a tough debate, discussion about appointment of judges. It started with transfer of judges from one court to another court by the government. Again, the people. I'm sorry to say it is the then governments. The earlier governments transferred judges from one court to another court. S.P. Gupta's case, popularly known as a judges transfers case, has repeatedly transferring the judges. One judge has been transferred 8 times to 8 different jurisdictions. Because I'm apprehensive that he may not give the judgment in my favor. As a result, subsequent to S.P. Gupta's case and then Supreme Court Bar Association case, there are a number of cases where there is a common understanding between the judiciary and the government, and the executive, not even the government. They framed a memorandum of understanding. What for that memorandum of understanding? That memorandum of understanding is for appointment of judges. Friends, ladies and gentlemen, distinguished delegates, this is purely an executive action. This agreement is an executive action. This memorandum of understanding is not having any sanctity of law. On the basis of this memorandum of understanding, both agreed, okay, judges will be appointed in this manner. And this memorandum was further amended that no, there is something missing in this memorandum of understanding. Let there be a representative of the government also in the process of selection of the judges. That is what the recent Supreme Court Bar Association and other cases. Now, very recently, the Supreme Court again says that no, while appointing the judges, we must have the full details of their IB record. Easy a disciplinary authority or easy vigilance authority or easy a commanding authority to know about all these details which are highly confidential? Okay, we don't debate on that. This is what is the present position regarding appointment of judges. Now the government, by exercising its legislative power, legislature is a power, is an organ under the constitution. The government enacted a law. It's a fully accepted law by the parliament, consisting of Lok Sabha and Rajya Sabha. So this law has a constitutional mandate. Article 246 read with the entries of list 1, this law was made by the parliament. The National Judicial Appointment Commission Act. It is unfortunate that the Supreme Court says that this law is unconstitutional. Who are you to decide that? How you are interpreting the law? You are saying that your executive memorandum is superior than the law passed by the parliament. Then what for this 550 plus 295 members of the parliament are sitting there? You want to appoint yourself? You want to judge yourself? You want to close cases against yourself? In the name of judicial autonomy? The reasoning that was given is that if it is through this NJAC, through a law, it affects my autonomy, it affects my individuality or independency. But you are getting salary from the government of India, Consolidated Fund of India. Then don't take salary from Consolidated Fund of India. You create your own fund and appoint yourself. Nowhere in the world, judges are deciding their own cases by themselves as an authority of appointment authority or as a disciplinary authority. Now again, the question before us is whether it is a failure of the constitution or failure of the people. Friends, ladies and gentlemen, in the present days, lack of proper understanding of the constitutional provisions, right or wrong, whatever may be the past. I'm not going into the debate of its validity, its sanctity. But today it is a power document because from cradle to graveyard, as on date, we are governed by this Constitution of India. If a child is born, If certificate is not properly issued, birth certificate is not properly issued, the child has a right. She can go and knock the doors of the High Court and Supreme Court under Article 32 and Article 226. That's why Ambedkar, though he said, I would like to burn the constitution copies, Ambedkar again said, if I was asked which is the most important article under the Constitution of India, without which the Constitution of India will be null and void, I don't hesitate to say that that article is nothing but Article 32 of the Constitution. I unquote. So such a power is given under the Constitution. Even a single letter, a postcard written by a prisoner who is undergoing imprisonment was considered as a writ petition by the Supreme Court. And the matter was decided by the Supreme Court. Justice was done. If a worker is not paid the minimum wages, in assured workers' case, the Supreme Court held that not paying minimum wages is a bonded labor. It amounts to beggar and it is punishable. Our constitution emanated from that position. But today, the scene is different. The scenario is different. So that is one factual position. And third important factual position. Repeated amendments of the constitution. One glaring example we have just witnessed. The term secularism is not there in the original constitution. Subsequently, it is added. Again, I am not going into the debate of secularism, what secularism is, what secularism should constitute. But there is a debate about the minority interpretation. Suppose I am a Telugu-speaking person residing in a northern hemisphere of Delhi, I am a minority. I am in a Hindi-dominated northern hemisphere, coming from 3,000 kilometers away from Delhi. I should get the minority status, but I am not getting under the Constitution of India. So I am not going into the debate, but I am talking about the repeated amendments of the Constitution. By vexed with these repeated amendments to the Constitution, one of the eminent constitutional luminary, Mr. Nani Palkiwala, he once commented on the Indian Constitution as defaced and defiled. Again, I am not quoting from my own diaries. I am quoting from Mr. Nani Palkiwala. There is a book authored by him, Our Constitution, Defaced and Defiled. And also, Mr. Palkiwala also said in an open hearing case, vexed with the amendments that were made, especially with reference to 44 amendment, to safeguard the election of one of the political personalities of this country. He said, I quote, Indira can amend the constitution, mend the constitution, and end the constitution. I unquote. This is what Palkiwala said once. So again, by repeated amendments, if you deface the constitution, rightly or wrongly framed by the framers, is it the fault of the constitution or fault of the people who are interpreting? Now I give the fourth live example. A very glaring practical example. Friends, ladies and gentlemen, I don't, as a legal advisor, as a researcher, as a teacher, I don't have any other inclination to any other political party, but I have a strong emotional inclination towards my nation. I don't mind to die for that. It's my nation, my country. It is not I, it is my. I come from with that strong fundamental education or basis which I had all these years. We all know the pathetic condition that prevailed in one of our states, Jammu and Kashmir. The starvation, the struggle, even it was picturized. Again, there is a controversy about the picture saying that no, it is politically motivated. How it is politically motivated? Some of you asked a question about freedom of speech and expression. If I make a film by exercising my freedom of speech and expression, is it politically motivated? Am I not entitled to make a film by exercising my fundamental right under the Constitution? So this condition prevailed only because of one particular article, Article 370 of the Constitution. Why it took more than 70 years to bring a change in this article. The courts have repeatedly interpreted, no, you cannot touch. Now, why the courts are not saying anything about the amendment? Coming to this is another glaring example. Coming to another live case to speak about the understanding, interpretation, or failure of the Constitution. There was a discussion, there is a debate about religion, secularism, etc., etc. No doubt the Constitution guarantees the freedom of religion. But my question here is this particular article in the recent past was rightly considered, rightly interpreted, rightly understood, or rightly digested? The best example is about the Sabarimalaya case, about the Ram Setu case, and about the jihad, that recent Karnataka controversy. Hijab, sorry. Are we rightly interpreting our freedom of religion as incorporated under the Constitution correctly? Are we really interpreting legally the principle of equality as enshrined under the Article 14 of the Indian Constitution? Equality amongst the equals. Are we equally treating all religions? If it is a celebration of a Diwali, there will be a restriction. No, it is air pollution, it is sound pollution, it is environmental pollution. Why you are not imposing such curbs for other religions? It's again a $1,000 billion question, especially all the professionals and the young children should analyze and come up with some correct legal interpretation and correct legal understanding of the constitutional mandate. Constitution never said the interpretations that were given by the courts in some of the cases, with due respects and due apologies to the legal acumenship of the judges who occupied the position. Unless until you understand the position, understand the legal interpretation in the correct way, it will be very difficult to give or to come up with a judgment. That's what Justice Chalmers mentioned in his minority dissenting judgment about the NGAC. Please go through the minority version of Justice Chalmers' version in NGAC's case, which clearly reflects the correct legal interpretation. I am not against of any one particular judge or any one particular judgment, but I am against of misunderstanding, misinterpreting the provisions of the Constitution. You interpret them in the right way, in the right sense. Then only we will be achieving the objects of the Constitution as enshrined under the Constitution. To do so, one must have a strong understanding of the preamble of the Constitution, because it is a key to open the minds of the people. At least you understand whether the provisions are right or wrong, that we will debate later. You give the correct interpretation. Don't give misleading interpretation by saying that this is unconstitutional or this is illegal. And at the same time, the last but not least, there are no watertight compartments under the Indian Constitution regarding the legislature, executive and the judiciary. Though there is incorporation of the concept of separation of powers, we don't have watertight compartments like the American Constitution. In American Constitution, the executive cannot enter into the domain of the others. But today we are having judicial executive directions in a very expansive interpretation of the Constitution of India. No, but that is again a very dangerous suicidal point to be considered for protection of the values of the Constitution. Expansive interpretations are very dangerous. You limit your interpretation only to the law, what it says. No doubt you are a court of justice. That doesn't mean that you can expand anything which is not written there. And the Supreme Court, in the recent past, repeatedly entering into the domain of the others and trying to give directions. You take it, directions in the form of investigation, directions in the form of making of a law, directions in the form of reduction of the tax rates as decided by the GST Council. When there is a statutory council created under a law passed by the Parliament, if the GST Council takes a decision within the framework of law, This GST council is a council represented by all the states. Every state finance minister is a member in that. And finance minister of the central government is a chairperson. When they take a decision, when they agree something in the council, how that decision becomes unconstitutional later point of time? Is it for the job of the Supreme Court to decide whether the decision taken by the council is right or wrong? No doubt they can intervene if there is any arbitrariness, if there is any Wednesbury principle, they can intervene. They can step in and decide whether the decision is right or wrong. But in the absence of such a scenario, the Supreme Court cannot intervene. But unfortunately, there are decisions in this regard. And the court again repeatedly said in economic policies, it is the wisdom of the legislature and the wisdom of the executive. But even on economic policies, they are stepping up. Whether a sovereign bond issued is right or wrong, it is for me to take a call. Who are you to decide that? It is my conscious decision. Tomorrow the Supreme Court also may say that what you should eat and what you should not eat. So these are the a few, but there are good sides of the interpretation of the Constitution also. The Supreme Court come up with various laudable interpretations while interpreting various provisions of the Constitution, whether you take it from the Keshavananda Bharati's case or from the recent interpretations. Even before enacting a law in India on safety at workplaces regarding avoiding of sexual harassment of the women at the workplace, by incorporating international law into our domestic law, the Supreme Court has given a decision, Vishaka versus State of Rajasthan. When this case was decided, India has not signed the CEDAW Convention on Elimination of all kinds of discrimination against the women. India has not signed the convention, but the courts interpreted it. It's a good point. To curb the pollution, especially from the tanneries in the state of Tamil Nadu, the pollution caused because of the tanneries in the Tamil Nadu and other states, the court have come up with various principles like polluter pay, public trust document, etc., etc. So there are positive interpretations, there are negative interpretations. So when we start analyzing ourselves, it is good and quite laudable and thankful to the organizers for raising this highly debatable issue of working of the Constitution in the name of Colloquy on the Constitution. So we as a people, not only as a people, as a man and woman of prudence, we must analyze where is the fault, curb the fault, fix the responsibility, impose the duty. Friends and ladies and gentlemen, distinguished delegates, I conclude with one last saying that as I started saying that rights and duties are correlative of each other, I am sure my sincere feeling with the blessings of the Almighty Lord Rama to establish the Rama Raja as aspired by the people of India. And in India, there is a place even till today, the people consider Rama as a Raj. That is in Madhya Pradesh, Urcha, a beautiful Rama temple, very old ancient Rama temple. There's a big story about that Rama temple. There Rama is a small boy, in the form of a boy, that the Bundelkhand queen requests Rama to accompany her because her husband curses her and imposes a condition that you can enter into Ursha only when you come with your Rama. So she goes to the Sarya river to commit suicide. Then a small boy appears before her that, what is your problem? Why you want to commit suicide? She says, no, this is the condition imposed by my husband. Unless the Rama comes with me, I cannot go to my place. He said, I am Rama, come, we'll go. But upon one condition. Once you place me, you ask me to sit a particular place, I will sit there only, I will not move from that place. And what she did is, she went back to her palace, and in that anxiety and happiness to convey the news to her husband king, she said, please, Rama, you sit here, I'll just go and convey about your arrival to my husband, and then we'll go to the temple. A temple was constructed for him. The moment she turns back, Rama becomes a statue there and he sits there. So the temple is there, Rama is there. There the people treat Rama as the ruler. Even I was told, I don't know, I have not witnessed. I was told that even on the Independence Day and Republic Day, the salute will be made to Lord Rama there. So, friends, ladies and gentlemen, to aspire this, to achieve this Rama Rajya, I am a strong believer of Rama. I don't hesitate to accept that. If every one of us and every organ of the constitution, whether it is legislature, whether it is executive or judiciary, if every one of the organs perform their duties sincerely, honestly, solemnly, then there won't be any discussion of violation of any right, violation of any duty. Even before the rights of an arrested person is enacted in India, the courts have interpreted the rights of arrested persons. Before enacting of right to information, the courts have interpreted the right to information and considered it as a fundamental right under the Constitution. Today, one of the speakers, he spoke about the data privacy and data protection. Even before, though we don't have a data law, the courts have protected our data. In Puttaswamy's case. And one more interesting point I want to share, that even the countries where the data protection law is there the violations are the maximum. US is one of the biggest cyber attacked place, though they are having a data protection law. UK is another example. And in US, even their railway tracking system was hacked and caused inconvenience. So therefore, my only submission is, if rights and duties are correlated to each other, if duties are performed, there won't be any outcry of violation of the rights. But as I mentioned, it is law being a living organ, cannot remain static, no doubt. We must analyze with these examples and illustrations to find out where the fault lies. And again, to conclude, I quote from Justice Bhagavati, "There shall be a revolution in India through law. Otherwise, there will be a revolution against the law." So to avoid a revolution against the law, there shall be a revolution in India through law. So if the time necessitates, definitely we should have a change in the law. But one last submission to the organizers, to make this job, this task easier and simpler, to make the people to understand the constitutional provisions in the right way, in a very coherent way. If permissible, you can make a data, you can maintain some data, you can collect some details and some case law and all these things, so that there can be an education. Not that people are not educated. Unfortunately, in India, we have many educated, uneducated people. So we need education to those educated, uneducated people. So therefore, my sincere request is, if you can maintain some data and some information, even you can publish a kind of a quarterly or an half-yearly or an yearly compendium or something like that, that may be helpful in this regard. With these few words, again, Endro Mahanubhavulu Andariki Vandanamulam. That means there are many great people, and I bow before all those great people. With these few words, I sincerely thank the organizer, Mr. Bharat Gopu and Madam and Mr. Shyam, for affording me this opportunity. Sridhar sir, really I am honored to be one of your speaker along with you. It's a great honor. Thank you very much. Thank you all. Great pleasure, sir. In fact, I joined law by taking inspiration that there will be an NGAS. I'm disclosing the secret. I cleared my law set examination in 1987, and I picked up this profession. Basically, I want to be a scientist by doing MSc ornithology or MSc plant breeding. I'm a biology student. But having heard the news of National Judicial Commissioner, National Judicial Examination, I was so attracted and tempted to take this as a profession, as a career. Unfortunately, even a golden opportunity that was proposed by the government was turned down by the judiciary. So you must think of the interpretation, the real interpretation of the Constitution. Thank you, Lord.